Hello and welcome to another episode of Attorney Vlogger. Okay? So I'm here today to help you understand some concepts in contract law. Okay? There are so many contracts with different names. Now we have a contract of sale, deed of absolute sale, contract to sell, memorandum of agreement. What are all these contracts, no? In order for you to determine what a contract really is, the rule is you have to determine the nature of the contract by its terms and stipulations in its body. Okay? In other words, the title of the contract may be different from the terms and conditions. And what do we follow? We follow the body. Okay? So even if a contract says it is a contract of sale, but its body reveals that it is actually a donation, then the contract is a donation. Okay? Because we follow the body and not the name. That said, now let's go into one more confusing topic. What's the difference between a contract of sale or deed of absolute sale? Pareho lang po iyon, it's the same. Or a contract to sell. Magkaiba po yung contract of sale sa contract to sell. Okay? A contract of sale is one whereby one party, known as the seller, obligates himself to deliver ownership over a determinate thing, and the other person, known as the buyer, to pay therefore a price certain in money or its equivalent. Okay? It involves a reciprocal obligation. Okay? The seller gives ownership over the property and the buyer gives the price. Kaliwaan po iyan. Okay? Absolute na po iyan. Consummated na po iyan once na magkapalitan na sila at yun na po. It is complete in itself. Whereas a contract to sell is simply a bilateral agreement between the buyer and the seller wherein the seller reserves ownership in himself. Akin mo na yung ownership ha, kahit bigay ko muna to sa'yo, akin mo na yung ownership until the happening of a condition, no? Because a contract to sell is actually a conditional sale. And what is the condition in a contract to sell? It is payment of the purchase price by the buyer in full. Okay? This usually happens in a sale by installments. No, let's say a condominium unit which is so expensive that it usually cannot be paid in one full lump sum, then the seller usually sells that in installments. Okay? So in order for the seller to protect himself, the ownership over the unit is retained in him until the buyer is able to fully pay the price. That is the condition which the buyer must meet, no, in order for the seller to enter into a contract of sale. Okay? Again, the seller reserves ownership in the thing until the buyer is able to fully pay the price. After the buyer has satisfied that condition of paying the price in full, they will now execute a deed of absolute sale or the DOAS. Okay? Those are two different things. Okay? Now, what is the effect if there has been breach? What is breach? One party to the contract has violated this obligation. He has not performed. Now, let's say it's a contract of sale. The buyer failed to pay a purchase price. Does the contract of sale exist? Yes, because breach or failure to pay the purchase price is not an essential element for the contract to exist. Okay? So, the contract of sale exists. But there is a breach. Okay? So, what is the remedy of the seller now? The seller can bring two kinds of actions. Either one for specific performance, meaning the seller can go to the court and ask the court to compel the buyer to pay the purchase price. Okay, that is specific performance. Or, the seller also has the remedy of rescission. Okay? In other words, the seller can ask the court to cancel the contract, and the effect of this cancellation is that both parties must return what they have given by virtue of the contract. In other words, kung may natanggap na si seller, isoli niya yung nakuha niya, or kung may nakuha man si buyer, isoli niya din. This is known as the principle of mutual restitution. Is the rule the same in contract to sell? No. In a contract to sell, since it is a mere preparatory contract, breach of the contract, no, will not give rise to a contract to sale. That is the only effect. No, there is no specific performance. There is no rescission. The only effect is that hindi matutuloy yung paggawa nila ng DOAS. Okay? However, in some cases, the Supreme Court has given equitable considerations and has allowed damages to be recovered, or in case the condition in a contract to sell has been imposed upon the seller instead of the buyer, then the buyer has the option to waive the condition and decide to enter into the sale. But as a general rule, the only effect of a breach of a contract to sell is that the contract of sale will not come into being. Last point, again, to reiterate, contract of sale is kaliwaan, and the buyer becomes the absolute owner of the thing upon payment, full payment of the thing. And in a contract to sell, ownership is reserved in the seller until the happening of the condition, which is full payment by the buyer. Okay? That's the difference between a deed of absolute sale and a contract to sell. Thank you. Please watch my other episodes.